Mrs. Riley David, here and others.
My cleaning room. Would you like me to remove my mask or I should
Mr. Prengo, yes, I think we're at a safe social distance.
I do so. My little friends, Mr. Pashwane, Ms. Hassan, and I are here for the minister.
Yes, thank you.
Good morning, my lord. Rainer de Beer, first applicant in the main application appearing in person.
Yes, thank you, Mr. De Beer.
Please, your lordship, Willis, my lord, I have appeared before your lordship.
Yes, you have.
My lord, I appear together with my learned junior, Mr.
Omar.
Omar, assisting me. Thank you.
Yes. I think there's still an amicus, Mr.
Yes. So since it will go to bring representing HBR Foundation as the amicus.
Yes. I have received shortly before commencement first respondents' heads of argument as well as heads from the amicus. They were very late. I've gone through them briefly. I've seen there's a point in limine raised by the first respondent regarding invalidity. I propose to deal with the matter in the normal fashion and deal with the points in limine as part of the argument. So I'll hear applicant, respondents, amicus, and then your reply.
Thank you, my lord. May I perhaps start with the point in limine taken by the Mr. Beer. We submit with respect to two reasons that the point does not avail him. The first is that Section 18.1 of the Superior Courts Act now regulates the suspension of judgments subject to an application for leave to appeal.
Yes, paragraph 3.3 of his heads, it says the 14 days keep running irrespective of whether leave was filed or not. But section 18.1 of course says the opposite.
Absolutely the opposite.
And the judgment that he relies on, I think the Heaton-Nichols judgment, refers to Rule 4911, which has been repealed in 2015.
Indeed, absolutely.
All right.
And let me also say about that case was a case in which the period of suspension had expired without an appeal. In other words, the order had become final. And the question was whether the court now had any power to do anything about it, and it was held not. But that is not our case.
Yes.
But the second point is this, that even if he's right, then it may be that it may found a debate about the immediate application of this court's order. You can't deprive my client of their right of appeal. And we are here merely to apply for leave to appeal. So if Mr. De Beer believes that despite our appeal, the Lordship's order has become operative, well, let him bring an application and enforce that claim. But it shouldn't stand in the way of an appeal. My client can't be deprived of her right of appeal merely because there might be no suspension.
Yes.
I don't need to address your Lordship on the test for leave to appeal, but
no, and there are two tests which the applicant relies on, particularly in the leave to appeal. That is that there is a reasonable prospect of success on appeal, or that there would be a prospect of success on appeal, and then the public interest, the section 17.
But even the first test,
yes,
doesn't mean we're going to debate whether the judgment's right or wrong.
No.
The debate is merely whether another court may reasonably come to a different conclusion.
Yes, but we are restricted though by certain parameters. We must be in agreement that the overarching restriction is that of the Constitution. And we're in agreement that this was executive action. And executive action must satisfy the test of legality. Included therein is the rationality test. That is that the measures taken to reach a certain objective must objectively be rationally connected to the objective. And they must be rationally taken, of course, in any event. And then once one decides on measures to reach a certain objective, and you do so rationally, and they appear to be rationally connected. Of course, once they impact on constitutional rights, one must do either as part of your rationality assessment or as a separate test then the proportionality exercise as to when those measures impact on constitutional rights, whether the impact or the extent of the impact is constitutionally justifiable. Not so.
Absolutely.
All right. And in that then you say another court could come to a different conclusion on these facts.
Let me say, we do not quibble with your Lordship's analysis either of the legality requirement, i.e. the rationality requirement, or the requirements for justification for the limitation of a fundamental right. What we do say, however, is that the basics of pleading, and in fact the basics of a fair hearing under Section 34 of the Constitution, is that a respondent has to be properly informed of the case she has to meet, to enable her properly to respond to it. And that requires, firstly, for a rationality challenge, that an applicant should plead that Regulation X is irrational because its purpose is Y and it doesn't rationally advance that purpose. So that the minister is then called upon and alerted to the need to justify the rationality of that regulation. If the pleading is not, if the issue is not raised in those explicit terms, then the minister doesn't know what rationality to justify of what regulation and for what reason. And so that we submit with respect, as far as the rationality challenge is concerned, it is critical in terms of Section 34 of the Constitution that the rationality attack be explicitly pleaded and that sufficient detail of it is given to inform the minister what regulation is said to be irrational and why is it said to be irrational, so that the minister can put up her rationality defense on it. The same applies to a challenge that the regulation limits a fundamental right. Your Lordship is quite right in your legal analysis that once there is a limitation demonstrated, and let me say immediately, these regulations limit a vast array of fundamental rights, and that's not the point.
Yes, but that's also what the current respondent said. Now, I am aware of the formulation of constitutional attacks, and you've highlighted that, or the applicant has highlighted that, in the application for notice for leave to appeal, referring to various cases, which are all tried. But, Mr. Prengo, the more patently obvious a limitation is, certainly the less you need to detail it. If the constitutional right, for example, freedom of movement, is that you may go wherever you want to in the country, and someone suddenly says, but you can't. Well, how much more must one then delineate the attack?
No, but with respect, the regulations, for instance, very many regulations limit freedom of movement. And it may, some of them are patently justified. Some of them might be doubtful. Some of them may seem to be patently unjustified. But it is for the pleader to say to the minister, I attack that regulation because although you permit funerals, you don't permit night vigils. And I tell you that that seems irrational to permit the one and not the other. To allow the minister to explain why funerals are permitted but night vigils
Yes,
not.
now I can follow that on the rationality argument, but on the constitutionality argument, once you limit, isn't the limiter under the obligation to justify the limitation?
Yes.
Or the infringer?
You at least have to say this regulation violates that right for this reason. You remember that the Bill of Rights attack is raised in a one-liner. They say these regulations violate lots of rights under the Bill of Rights. I'll tell you an argument what rights I mean.
No, sure, but prior to the regulations, all those Bill of Rights were intact and exercisable.
Absolutely.
And there was little quibble about level 4 limitations, and that was part of the disaster and justifiable issue. But once beyond that, and once you said that I am still going to, I'm talking I know, but once the decision maker says the limitations are going to continue, how much more must one say? Must one then delineate or particularize every regulation, or must one just say those regulations that limit my, let's take it, right of association need to be justified, or the proportionality need to be justified? How difficult is it for the minister to determine that?
No, well, it's very difficult when you have a whole array of regulations, all of which limit freedom of movement. You'll remember that in fact, the default rule was created,
Yes.
which said nobody may leave their residence except, and then there are exceptions created.
All right.
Now, what is the case? Should you not have a default rule in the first place? Should you have more exceptions? Should you have some
Well,
exceptions?
shouldn't
but not
every
have-
one of them have been justified?
No. that's
The
correct.
default rule should be justified,
No.
of course. And then when you alleviate your default rule, which you've now imposed on the limitations of movement, do you need to be told how far that is to go or not? Surely isn't the principle that he who infringes must justify his infringement on the proportionality basis on the weighing up of other rights?
Is absolutely right in articulating the onus, but not the
Yeah.
requirements of pleading.
All right?
Pleading requires that the minister be informed what regulation is under attack, what aspect of it is under attack, and in breach of what rule it is, so that the minister can justify it. And Lord, and let me say that particularly when it comes to the alleged violations of the Bill of Rights, that attack was pleaded in one sentence. All of the regulations violate very many rights. It makes it impossible to determine.
No, sure,
what it
but
is.
there were separate parts of the application which dealt with association, for example, gatherings, religious exercise of religious rights as well. So although there's the one line in the conclusion, certain others were at least identified.
Your Lordship is quite right that certain specific attacks were made, but the court did not uphold those specific attacks. Now, none of the court's ultimate ratio upholds any of those specified attacks, and we can of course re-argue the whole case. We submit
No.
with respect that
You say there's a prospect another court can say it should have been articulated or particularized, otherwise there's no sufficient detail of the attack, and that prejudices the minister's minister's right of access to court because she doesn't have a fair hearing, because she doesn't know what she must
Yeah.
deal with. It's a mere blanket attack or a shotgun approach.
indeed, and that is on the pleading side, and then on the ultimate ratio, the ratio of course turned on the level 3 regulations, which were only promulgated on the day of the hearing.
Yes.
Your Lordship is very well alive to it, and I appreciate Your Lordship's sensibility in turning to the new regulations rather than the old. But it does highlight the fact that no constitutional attack on those regulations were before the court at all.
But there's one thing as well one must bear in mind. The parties, all of them, but in particular your client, through your predecessor, insisted that before I give a judgment or consider an order, I view the attack as it was in view of the level 3 regulations promulgated that day. It might be that the concession or the urging for me to do so was the perception that that level alleviates a lot of the restrictions and might be more in favor then of the attack of the minister. But that was expressly mentioned. And that's why I also mentioned in my judgment that the parties said that I should do so. I've checked my bench book again and my hearing, and I have more than one note. In fact, the respondent at that time, the current applicant, says the judgment should be delayed to take the new regulations, this level 3 regulations, into account.
Lord, let me say I wasn't here, and I accept entirely what your Lordship tells me about it.
But it's in the judgment, that's why I refer to it in the judgment, so the parties urge me.
I absolutely accept that.
The only difficulty is that it wasn't argued and particularized either way, either by the then applicants or by the respondent.
And therefore, by definition, not pleaded, and we submit beyond the scope of the matters properly before the court. And no amount of concession or urging on your Lordship. I can understand a debate that says, don't strike the old regulation down if it's been replaced by a new one which cures the defect. Because that would be an argument to say the point has become moot because the regulation has been overtaken. But to shift the attack entirely to the new regulations, which had not been pleaded, we should submit with respect was unfair to the Minister and beyond the scope of the matters properly before the court in those circumstances.
Yes, all right, I hear the argument.
Then there are two further points, my Lord. The one is that the court held some of the level 3 regulations to be irrational, and then on the basis of that finding, declared all of the regulations, level 3, 4, and everywhere, all the way back, to be invalid. We submit with respect that the finding that some regulations are invalid does not then justify an order declaring all of the regulations to be invalid.
Weren't those simply examples of the extreme irrationality of some of those?
The court made it clear that its view that the regulations were irrational was not confined to the specific examples you mentioned. Yes, indeed, my Lord. But we do submit with respect that there is simply no basis in law on which one can conclude that because some regulations are patently invalid, therefore all the others regulations should be struck down.
That's now the wholesale declaration argument.
Indeed. Yeah.
Mr. Tringo, assist me with this. If that argument might hold good regarding a rationality exercise, what about the process rationality concept regarding the Constitution? If on the papers it appears that at no stage was there the proportionality exercise done regarding constitutional rights, doesn't that taint all the regulations?
Only if you can make that finding in relation to all of them.
No, but say a regulation might be constitutionally justifiable on a proportionality test, but it is only by chance that it is so, because there was no prior consideration done. Will that survive then a test or not?
Well, let me say, my Lord, your Lordship is quite right to refer to that as the procedural rationality requirement. I'll come to it now. Let me just say this. Firstly, the justification requirement, the section 36 requirement, the substantive part of it, that is an objective test, and your Lordship is not concerned with the way in which the rule was made. He was concerned only with the question whether the rule reasonably limits the constitutional right. It is quite correct that there is the rule of law also incorporates a requirement of procedural rationality. And if none of the regulations were made by procedurally rational process, then that would be a reason to strike down all of them. But the process by which they were made was not a pleaded issue, was not canvassed by anybody on the pleadings. And we submit with respect that it's not open to the court to come to such a drastic conclusion on an issue which was never pleaded and never addressed in the evidence.
You say even if I find that once there is, or am of the view that once there is a infringement of the constitutional right, the infringer, if one can call it that, has an onus, as we've discussed, to to justify, and I'm of the view that it includes the procedural process. You say that another court could find, well, if there wasn't a sufficient attack on that, there's no need to explain or justify even the procedural.
Let me just make clear, I'm not suggesting that such an attack is not a permissible one. But it's again the fundamental requirement that the minister needs to be informed of the nature of the attack on the regulation. Is the attack that the regulation was made by an unfair procedure, or is the attack that the regulation itself unreasonably limits the right, or is it both the procedural and the substantive attack? But you can't launch what appears to be a substantive attack and then seek to make a case on procedural grounds when that was never pleaded and never made.
And you say that basis a court of appeal could find differently.
Indeed. And I'm not saying that the court might not uphold, I don't know whether there will be a cross appeal, there might be one. The court might not uphold some of the other specific attacks. The only question is whether on this order, another court may come to a different conclusion.
Well, on the question of a cross appeal, shouldn't there have been then an application for leave to cross appeal?
So it would be open to my learned friends to defend your lordship's order on whatever ground they contend the papers allow them to do so.
All right.
We submit in respect that there is at least a reasonable prospect that another court will conclude that the findings of this court, based on the level 3 regulations, were unfair to the minister because they haven't.
Thank you. Thank you, Mr. Pringle.
Your Honour,
Mr. Willis?
I'll be addressing the Lordship ahead of Mr. De Beer by agreement with Mr. De Beer.
All right.
The Lord, the attack or the approach for leave to appeal is a very narrow one. If I could start with the criticism surrounding the lack of pleading of level 3, which is correct. Level 3 regulations were not pleaded. They couldn't be pleaded at the time because they hadn't even been announced at that stage. But my Lord, just looking at level 4, which was attacked head on, how were the applicants, and in this case a lay person, how were they to know what sort of procedural attack? Because they do so in as many words. If one, if this should take your lordship to the papers in a moment's time, there's definitely an attack on procedure. It's somewhat broad and inelegant. It's in relation to the regulations as a whole. It's somewhat tied up with the case which your lordship did not uphold in relation to the lockdown, the declaration of a state of emergency.
Well, in the absence of an application for cross appeal, that stands.
Correct. We don't take issue with that. I'm just highlighting that that's where one locates it.
Yes.
And inelegant it might be, my lord. But what more could they say in circumstances where we're dealing with regulations that were made without even parliamentary oversight? In fact, my lord, there's no case they were even made with cabinet oversight. These are the minister's regulations in this instance. I refer to the minister. I'm cognizant of the fact that her Director General deposed to the papers, but I will nonetheless refer to the papers as the minister as if she had deposed.
Well, that's the justification for the minister's promulgation of the regulations.
Fine.
Whoever deposed to it.
And my lord, the connection between level 3 and level 4, or level 4 going down to level 3, my lord, they come from the same place. They're made of the same DNA. They come from they are of the same DNA, and they were promulgated under the same, or I submit to your lordship, lack of political will to consider the Constitution, to consider the objectives in section 27.3. Where did we learn about that, my lord? The only place truly one could have learned about it is in the answering papers. It wasn't possible to have pleaded any more precisely on the procedural attack. I don't think I need to take that point to the floor. Lord, as to the complaint that there was inadequate pleading in the constitutional challenge in the founding papers, if your Lordship, there are two components to that. The one is, yes, a complaint of some sort of deficiency. But, my Lord, as much as a constitutional attack must be pleaded and appropriate, and our learned friends set out the law, and we don't quibble, of course not, with any of the law that they set out. But, my Lord, those same authorities, and in particular, maybe I should just take your Lordship to the application for leave to appeal, if I can just find it here.
Well, it is on case lines.
It is indeed, my Lord.
In item 073, you'll find it there.
I have the pages numbered. So, my Lord, if you go to page,
Well, I have a hard copy, though. You can just refer to the paragraphs.
I'll refer to the paragraphs. If one goes to page, or paragraph 7,
That's the matter of Prince.
that's the matter of Prince, the initial Prince matter. If one reads, and let me just read it from the top, Lord, parties who challenge the constitutionality of a provision in the statute must raise the constitutionality of the provision sought to be challenged at the time they institute legal proceedings. We say that was done. In addition, a party must place before the court information relevant to the determination of the constitutionality of the impugned provisions. We say that was done, my Lord. And if I remind your Lordship as to how the papers were set out, Mr. De Beer, who drew the papers, I have my attorney and my junior assure me that those are only Mr. De Beer's papers, so I make that submission, my Lord. He sets out a summary, which is more than a summary, it's rather detailed, and then he goes through as if he almost had seriatim, and those paragraphs, you recall the structure, my Lord, and he details it, my Lord. The detail with respect is there. I'm not here to re-argue the matter, and I won't revisit it unless you But then the Lord in Prince, Justice Bobo, says, similarly, a party seeking to justify a limitation of the constitutional right must place before the court information relevant to the issue of justification. Your Lordship's criticisms are relatively severe in the papers. I just leave that there for now.
But Prince's matter is slightly different on the facts, though. In Prince's matter, the constitutional point was raised at the late stage of the proceedings, on appeal, I think. And I think the comments of Judge Ngobo should be viewed in that context, to say that if you haven't started out laying a factual foundation or a challenge, how can you do so later on appeal?
The Lord in Prince, as I recall, casting my mind back, there was that difficulty, and then there was the difficulty too with the extra affidavits and the facts that came into it. But it was clearly identifiable ultimately for the court, adequately for the court to deal with, as I recall. And the Lord, but the point I want to make, your Lordship, reading on from the commencement of the last sentence of the page, I would emphasize that all this information must be placed before the court of first instance. We say that occurred. And then the placing of the relevant information is necessary to warn the other party of the case it will be. But Lord, there's an obligation on both parties here, so as to allow it the opportunity to present factual material and legal argument to meet the case. It is not sufficient for a party to raise the constitutionality of a statute only in the heads of argument. And my Lord, there is a distinction here that our learned friends focus on, and that's the raising of a constitutional challenge. If one goes back to, there are some slightly nuanced standards if one is simply assessing an issue raised in a set of papers, and whether it was adequately raised. And we appreciate that can become rather complex. But I submit to your Lordship that the nub of their argument is this, that you didn't break down regulation for regulation for regulation. That's all it is. And my Lord, we submit that in this case that wasn't necessary. If one accepts that it's a full frontal attack on the regulations per se. It was to say each and every regulation violates, and each and every regulation is irrational, and there are numerous examples that are named. It is correct. Far less than each and every regulation is addressed in the papers. But what is not correct, my lord, is that paragraph 10, the single paragraph, is where the case is raised. It's not, my lord. That is just an almost conclusive submission under the pen of Mr. De Beer. Everything is raised in paragraphs 3, 4, 5, 6, 7, 8, and 9. And your lordship had regard to that. Lord, the requirement is that you can't raise issues, take a party by surprise in your heads of argument. It's really where the tacky hits the tar, so to speak, ultimately. There was no surprise here to the minister as to what case she had to meet. She came before your lordship, but there was some delay in filing papers, and nothing really turns on that, my lord, except this, that she ultimately had her opportunity to present her case. I am informed, and my lord, I was given a copy of the heads of argument by Mr. Peshwani, and
For this application or in the...
they were the main application before your lordship.
Yes, they're also...
It's not on case lines, I'm told, my lord. But they were the heads of argument that were placed before your lordship. And if I can refer to paragraphs 23 to 25, and this was the approach of Mr. Peshwani acting for the minister. The minister raises a number of defences, mainly on the fact that the decision to declare a national state of disaster was justified by the circumstances, was on the strength of the medical advice, experts' opinions and observation of what other countries were experiencing. If a national state of disaster was not proclaimed, etc. And then 25, there is no legislation and contingency arrangements which can effectively and adequately deal with the outbreak. Well, the Lord, that point there wasn't part of the minister's case. She didn't rely on an inadequacy of legislation. She relied on the need to augment it and the special circumstances. But the point of this, my lord, is you won't find...
The augmentation already implies that there is an insufficiency, which you should have known and considered in declaring the state of disaster and in making the regulations.
And that all ought to have been placed before your lordship. The papers are deficient, are grossly deficient by the minister. But my lord, the point that I seek to make at this juncture is they're not deficient because the minister was not given adequate opportunity. And to complain about, as was said in the application for condemnation, to complain that, well, there was all this other litigation going on. The Chief Justice has long since said the state must get its house in order prepared for the litigation that comes its way. But Lord, the point is that they came before your lordship having assessed the case, they understood the case, they knew that this was a full frontal, they knew it was substantive, they knew it was procedural, and that is why they settled the defence such as they did, and they ran into the difficulties that they did with your lordship in relation to means and ends, not applying the test or not understanding the test adequately. It doesn't matter which way around, whether it means ends means. The point of the matter is, my lord, is that no case was placed before your lordship to either justify or to rationalise.
So you say they would not succeed on appeal on that issue and therefore no leave should be granted?
In your lordship's words, or the debate between you and Mr. Trengrove, they simply won't survive an ultimate re-hearing of the matter. My lord, as to the wholesale declaration, Lord, I think, my lord, that in my submission to the lordship, that point on behalf of the minister only survives if you find for them on the basic pleading point. Because once you don't accept the pleading point and that there was a deficient pleading, an impeachable pleading, well then, my lord, your judgment deals with all of these other factors. The order, my lord, we know is the executable portion of a judgment, the operational portion. If there's any difficulty in understanding what your lordship ordered, well, then one interprets the judgment. And my lord, we submit that on the judgment, there's no scope for misunderstanding. That, my lord, goes to the vagueness point equally. My lord, that brings us to the compelling reasons, the second leg. My lord, if there are no prospects of success in this matter on these facts, then, my lord, with respect, there's simply there's no compelling reason, there's no public interest to submit. If your lordship, however, is inclined towards being persuaded that another court, there's prospects of another court coming to a different decision, well then it becomes rather academic whether there are or aren't other compelling reasons to grant leave. But the other way around, the same doesn't
Well,
apply.
isn't the compelling reasons argument to say, irrespective of whether there's a finding of a prospect of success on appeal, on rationality, on constitutionality, on proportionality, the importance of the legality of regulations currently is of such a nature that a higher court should revisit it. Isn't that the argument?
That is essentially the argument. There are two reasons why it doesn't apply, my lord.
Yes.
It wants to consider that the courts and the higher courts need to opine on these. There are a myriad of other applications out there, my lord, that will find their way to the constitutional court, or likely. That's the first point. The second point, my lord, is that when dealing with these regulations and where they move from level 4 down to level 3, in fact, during the course of the proceedings before you handed down your judgment, my lord, a lot of this, while one wouldn't argue acquiescence in the judgment, there has been such a great degree of change, and there will continue to be such a great degree of change, that it becomes...
Well, if that had been the reason for the amended regulations, one would have known.
That's the interesting part, my lord. At the time that the minister filed her answering affidavit, she must have known what was to happen within the period that the matter was to reach.
No, but I'd speculate on that one point.
You do, but
Yes.
Lord, the fact
You
of the
said
matter is you
the
don't
compelling
find
reasons, you said there are no compelling reasons.
they're not there. On these facts, my lord, this is not a case where it's compelling that the one way or the other way of the one part or the other part of your lordship's judgment needs to be unraveled and considered by them. Lord, we ask that the application be dismissed together with costs, including the costs of to counsel, my lord. The closing submission, I'd like to submit to your lordship that the lordship recalls the papers. It's all set out there, my lord, and it doesn't amount to a degree of deficiency on these facts, my lord, such as your lordship. Certainly, there's no allegation that your lordship overreached. The allegation that you went outside of the pleadings, my lord, is I submit there's no case made out precisely save the wholesale arguments that Mr. Trengrove made out. To what degree your lordship went outside of the pleadings, except that you did deal with the regulations largely. You didn't deal with all of them, you couldn't, the circumstances of your urgent judgment, but how you picked them apart. My lord, as to the remedy that you employed under section 172, you were quite entitled to exclude such as you did. So, my lord, those are our suggestions.
Thank you.
Sorry, my lord, Mike.
Yes, taking.
Lord, I referred to for your lordship's assistance, the matter of KwaZulu-Natal Joint Liaison Committee. This is the MEC for Education. If I give your lordship the citation.
Yes,
2013-4, South African Law Reports 262, decision of the Constitutional Court, and paragraph 80. And it relates to formalism. you'll recall in the leave to appeal, I think what is stated by learned friends is that the complaint they don't mean, it's not just a complaint about formality. Here it's stated, formalism has many meanings, but Professor Cora Hoekstra helpfully describes one of its meanings as a judicial tendency to attach undue importance to the pigeonholing of a legal problem and to its superficial or outward characteristics, and a concomitant judicial tendency to rely on technicality rather than substantive principle or policy, and on conceptualism instead of common sense. Hoekstra is further quoted as follows: in cases displaying formalistic legal reasons, the merits often seem strangely divorced from the outcome of the case, so that it is difficult and perhaps even embarrassing to explain the case to a layperson. My Lord, these papers were taught by a layperson. The layperson gives clear expression to your Lordship as to why these regulations.
Yes, but I think Mr. Trengove's argument is less on formal or formalism argument. It's a substantive argument to say, irrespective of who drew the papers, his client needed to know what case had to be met. And formalism apart, if there's a lack of indication of the attack, then you can't be faulted on giving a limited defense.
My Lord, save this. If that is the answer, that a limited defense, that certainly is not what the papers or the head said. And even if one accepts, my Lord, the intertwining here of policy, of policy and decision making, my Lord, there's simply no compliance. There are these, I think your Lordship's words, Lordship described the platitudes in generalized fashion. The Lordship will recall your words in the judgment.
Yes.
And the point is that
dealing with the affidavit,
they don't. I think the Lord, if one has regard to how they dealt with their papers, their deficiency, the minister's deficiency was such that she didn't comply with the approach set out in Necro as far back, I think, as 2005, my Lord. His Lordship, Mr. Justice Chaskelson, and those are paragraphs 36 to 38. My Lord, there's simply no defence that's raised. It's not even a limited defence. The problem here, my Lord, was not the deficiency in the pleading by the applicants, initially the respondents today. The problem, my Lord, was the deficiency ultimately in the state's papers. Lord, I don't think I need to take it.
Yes.
Those are submissions.
thank you. Mr. De Beer, did that also include your submissions?
My Lord, it mostly did, but I just quickly want to highlight a few points that I've raised in my heads of argument. I start off with obviously the point in limine that I've raised.
All right. I think the point in limine is bad in law.
My Lord, if my Lord can just slightly give me a few minutes to quickly go in there.
All right, but you say the fact that there's an application for leave to appeal pending, or was an application for leave to appeal pending, it did not stop the running of the 14 days. It did not suspend the order. But Section 18(1) of the Superior Courts Act says it does. And the case you rely on deals with regulation, Rule 4911, which has been repealed.
My Lord, there's actually, in fact, on page 4 of my aids,
Yes.
I've specifically mentioned other Constitutional Court cases as well, not only that specific case. Madam Justice Nichols have extensively, yes, she did refer to the old Rule 4911. But what she did confirm in there, and she relied on other dicta from the Constitutional Court, she basically confirmed that the time period given in unconstitutionality, invalidity cases are dealt with in terms of the Constitution, which is supreme to this.
Yes, no, that is so, but I
Superior Court.
understand that judgment and the others referring to is that the invalidity stands, but if conduct is contrary to the Constitution, it is invalid. And the invalidity remains. It doesn't become valid at some stage. But when it's declared invalid by a court, that declaration of invalidity is then suspended if there's an application for leave to appeal. So that's the difference. And so the point on the running of the time period in terms of the order whereby the declaration of invalidity has been made and the remedying or rectifying or remedial action has been ordered, that has been suspended by the application.
My Lord,
But I will have regard to what you said, Nero. I will have regard to the comments raised or extracted from judgments regarding whether the common law rule and the suspension should apply in respect of a constitutionally invalid action or not.
My Lord, I assume respectfully that my Lord is not going to give an extemporaneum judgment shortly after, and my Lord is going to take some time
that assumption is
go
correct.
in there. So I would just like the court to obviously take the heads into consideration when preparing the judgment, and then obviously the court can take its time to evaluate that specific point. My Lord, I would like to refer this court to page 9 of my heads.
That's the argument that the current section 17(1) has the requirement of would be successful, and they're the judgments of Judge Bertelsmann and followed on appeal in a criminal matter. Yes. It's a higher bar than previously. It's not. It's a reasonable prospect. It's would the applicant be successful on appeal.
That's indeed correct. So
Yes.
what I, as a normal South African citizen, would like this court to consider is that if the court is sure that, or there's a reasonable possibility that the court has maybe erred, it will be in the interest of justice for this court to make a declaration that this matter should go on appeal. But as I can still remember, on the day when this matter was heard in this court, I remember that the procedure that was followed was very reasonable. All the parties were given ample time to present their cases.
But that's how it should be, Mr. De Beer.
And everything went according to what was expected, and even the court took a reasonable time to come up with the judgment eventually. So, if this court really is of the view that there could be something wrong with the judgment, then it would be obviously in the interest of justice to do that. But when we come to the interest of justice, I have mentioned on page 13, I've gone extensively into the interest of justice. And why I am of the view, respectfully, that this court must forget about technicalities, in the sense that the interest of justice must always prevail. In that, who is most to be affected by this judgment? It's the ordinary people in the street. The government is coming to court with a new approach based on a lot of technicalities. Yes, the law does make provision for those technicalities. But in terms of the Constitution, this court also have got the jurisdiction and the right to regulate its own processes. So, and it must lean towards the interest of justice. I have mentioned that if we look at what has happened. Nearly 2 days after this court granted the order on the 2nd of June, the government already announced that they're going to file for leave to appeal. The period that was given...
Mr. De Beer, that's the right of any party.
My Lord, the process that was given to them by this court have not been fully utilized. There was no consultation process, nothing was done except relying on the leave application. So if we are looking at, for example, I've referred to a matter, for example, in the foreign law.
On that matter, in paragraphs 9.4 and 9.5 of your heads, you refer to 2 foreign judgments. I don't know how far they've been reported. It is customary in this court that when one refers to either unreported judgments or foreign judgments, that copies be made available. I assume you have those 2 judgments, because otherwise you wouldn't have referred to them. Can you please forward copies of those 2 judgments, not only to myself, but to all other parties as well?
I'll do that as the court pleases.
But as soon as possible after we finish today, so that it can be read and considered.
I'll definitely do that, my Lord. The other important matter is paragraph 9.7.
Yes.
The African Charter for Human and People's Rights specifically does not even make provision for any derogation on basic human rights. So we are supposed to follow international law, and as a state party to the African Union, we need to follow this as well. In that, unfortunately, it seems as if the whole process that was followed did not take a lot of effort and a lot of means to reach to its objectives. My Lord, I have basically just touched on the most important matters that I just wanted to highlight.
And you also say that leave to appeal should be refused.
Indeed, my Lord.
Yes.
Indeed. As the court pleases.
Thank you.
Thank you.
Mr. Tringo, there was an omnibus, of course. Yes, Mr. Mutapeng. Mr. Mutapeng, I've received your heads, although late, but I've read through it. I'll take everything you mentioned then into account, except where you mention occurrences which took place after the hearing and after the judgment, of course, because that would constitute new grounds which, unless you want to say these are new grounds which could be advanced on appeal, that already implies leave, but I can't take into account actions which took place after my judgment.
No, I hear you, madam. The reason why we included, I know you're referring to the visual, the parliament visual sitting. In fact, the parliament visual sitting, my lord, it emphasizes the point of the classification. We have always raised the point, my lord, to say, initially, before we can speak about the lockdown itself, the disaster management itself, where does it start? It starts with the classification of the disaster. Now, the state is relying on the disaster, has confirmed to say that COVID-19 is a disaster. Our argument is, where is the assessment report? The impact analysis or impact assessment, the hazard assessment, and the vulnerability assessment. that the state has made for it to come to a decision that suggests that COVID-19 is a disaster.
All right, but
So, yes.
but that deals with the declaration of the disaster, which I have found on the papers before me to have been rational.
Yes.
And I take it from your heads as well in your argument that you are unhappy with that decision, but there's no application for leave to appeal or cross-appeal that decision. You say I'm wrong, I shouldn't have found that the minister was correct in finding it is a national disaster.
Yes, my Lord, the minister or the state took a decision on unreliable or untruth, nor even based on baseless facts. I mean, if you listen to the president when he was asked by the leader of the EFF about where are we, what are the impact, which is the same question that we've always asked, my Lord, prior. And the president, when the president responds, I quote.
Yes, I saw that.
You saw it.
Yes, that's in paragraph 21, isn't it?
Yes.
Yes. And then you go further on and you deal with this issue in paragraphs D and its subparagraphs, the health and death on COVID-19.
Yes.
And E is the same, is part of that. That's the declaration of national disaster.
Yes.
Yes.
Yes. My Lord, if we also look at where we speak about on D, in terms of paragraph D, my Lord, the state has always came out and every day we see reports of death to say there are so many deaths. And still again, my Lord, the state continues to perpetuate or to instill fear on baseless evidence. For example, my Lord, the WHO, which is annexure, the first annexure 1, in terms of the guidelines for certifying COVID-19 as a cause of death, it says, A, COVID should be recorded as a medical certificate, COVID-19 should be recorded on the medical certificate of cause of death for all descendants where the disease caused or is assumed to have caused or contributed to the death. And underneath, in the last line also, it says, in terms of terminology, the use of the official terminology COVID-19 should be used for all certification of this cause of death, as there are many types of coronaviruses. It is recommended not to use coronavirus in a place of COVID-19. This helps to reduce uncertainty for the classification or coding and to correctly monitor this death.
Yes.
Now, my Lord, the state has always said, if you look at the number of people that they are reporting to have died, even where it assumes, it classifies them to be under COVID-19. Now, if you look even into social media, where people are complaining to say, my uncle went there with a headache and he died, or he went there because of a heart attack and he died, the state will automatically push everyone to say it's a COVID-19.
All right. Now, how does that relate to the present question of leave to appeal on this judgment and order?
I'm coming to that one.
Yes.
Now, the leave to appeal, my Lord, if we grant the leave to appeal, the lives of ordinary people such as myself and many of people that are like me, my Lord, who are suffering, will continue to suffer because of the state who, instead of focusing on his constitutional obligation.
So you say leave should be refused because there's no reasonable prospect that another court would come to a different conclusion and not order the minister to reconsider the regulations from a constitutional perspective.
My Lord, yes, there's a point in one of our arguments where we are also raising the fact that, look, the state comes here and it says to us, it says to the court, may the court gives guidance, all right? The state has more than 1.3 million employees, advisors, professionals, consultants, attorneys.
I saw that's on your point that the order is not vague. The state has a large array of people to assist it.
Yes. Now, why does the state want to be spoon-fed by the court? Therefore, that is one of the reasons why we are saying the state has all the resources it requires. In fact, if it had focused, your judgment, my lord, was equitable. In the sense that it even gave a relief, an alternative relief to the state. To say to the state, look, go and amend these particular clauses and regulations and come
Right,
back.
as you can see, it's a busy news day. Nompumelelo Ziziba is waiting in the wings. She'll be bringing us the very latest with regards to
Of a defiance, of a fight, of saying, well, not exactly a fight, but I'm saying it takes their constitutional right, which is still oppressing the majority of South Africans in terms of their daily lives. Now, when the state, in terms of their daily lives, because now people cannot work. There are some who are still waiting for level 1 to officially work properly or to officially earn a living.
But Mr. Mutopeng, you can't reasonably argue that because the state took an option which you say is unfair, rather than comply with its constitutional obligations as found, that it should not be able to exercise its rights of appeal.
My lord,
You can criticize the minister all you want, but if it's a constitutional right to apply to a court for leave to appeal, then she can exercise that right.
No, we agree, my lord, that they must execute that right.
But
They will still execute at a later stage. It's fine.
But you say I shouldn't grant it.
We are saying we shouldn't grant them, my lord. If they want to explore other avenues, they're welcome. They still have that right to explore those other avenues, my lord.
And then you ask that I dismiss the application for leave to appeal.
Yes, I have to dismiss that.
In your heads you go a bit farther and you want me to set up a lockdown inquiry and so on. I don't think one can do that at this stage.
My lord, the reason why I'm saying that is, look at the state has, the state says you have overstrayed. Mm-hmm. We're sitting here, my lord, all of us. When the court questioned, raised an issue and said, because there is a lockdown coming in the next few days, and the level 3 is coming.
It wasn't the next few days, it was that day. In fact, it might already have been promulgated by the time of the argument.
Yes.
My question was, what use will it be, or how useful will it be if a court considers the matter and grants an order, knowing that the factual landscape is changing as we sit in court?
Yes.
It's then when the parties said, well, take that changed landscape in terms of the level 3 regulations into account.
Yeah. Now, it's amazing when we look at their filing affidavit, they speak as if they've never made such commitment. Now, it is the same attitude of the state that it has on normal citizens, where they promise normal citizens 350 rand, the unemployed 350 rand, right? And they'll still come back and say on the 15th, and they'll postpone and to say on the 1st, and they'll continue to postpone and not giving the unemployed the 350 that they requested. The same as, my lord, with the load shedding. They'll say, no, during the lockdown there will not be any load shedding, and then they'll turn around. When at night, when you're starting to cook, you find that there's no takas, my lord. Now, that is the attitude of the state, that it will say one thing and then turn around and say the other thing. So for such an attitude, my lord, we need to be able to be decisive and be able to not to grant them.
All right. Shall I interpret your argument on the basis to say, having regard to those kinds of that kind of attitude and the nature of the application, it is not one where there is another compelling reason to grant leave?
Yes.
The small Roman 2 section of 17(1)(a).
My lord, as I'm about to close, my lord, on the, what is it? Sorry. You see, all the reliefs, my lord, none of the relief the state has perfectly or at least reached a threshold of 80%. On the reliefs. We are now in day 85, my Lord. The poor of the poorest, people like myself, my Lord, are struggling. You know, for example, I'll give you an example, my Lord. Our website, we couldn't even pay as an NGO our website. Because we can't even raise the funds. Why? It's mainly because of the lockdown. Now, if you look at the taxi, my Lord, the taxi, in terms of transportation, the taxi assisted the country during hard times. All right? And in terms of assisting, they complied and give, they even reduced the number to try and make sure that our gogos go to the hospitals. Our pregnant wives go to hospitals, and our sisters and brothers, the few ones who are still employed, goes to work. Now, when the state comes back, the very same state, instead of when it gives a grant to the bank, 200 billion, it puts no conditions to assist the very same people who are assisting the country to survive during hard times. That is the kind of state we're talking about, my friend. That's why I'm saying, that's why we're calling for that.
So let me interpret what you're saying. You're saying the infringement on the Section 22 Bill of Rights to be gainfully employed is unjustifiably infringed to such an extent another court wouldn't come to a different conclusion and leave to appeal should be refused.
We agree, my Lord. That's exactly my words.
Thank you.
My Lord, every day we see companies retrenching. SABC is retrenching.
Mr. Motopeng, not to limit your argument, but
yes.
is this more examples of the same point we've now discussed?
Well, I'm just trying to show you a different, another point here, madam, where I'm saying we are closing the economy on with the state. In fact, let me put it this way: the state has brought a disaster to its own people, to the country. It is not a COVID that is a disaster, but the state actions are a disaster to its own people, to all South Africans. Why am I saying this? You are taking something that does not, that kills or that is very harmful to people who have underlying health conditions or their immune system is weak, which is COVID-19. And you stop the entire country on the flu. Like any other flus that are there, millions and millions of flus we are exposed to in the country. And you are stopping the country because of flu. Why isn't that the state did not say, because of this COVID-19, and it goes back to the justification matter. If the state had identified that this COVID-19 is dangerous for people who have underlying health conditions and the elderly, then the state would have taken a different approach. Instead of discriminating 99.99% of the country, discriminating against, of saying, all of you who are healthy, who could be running the country, instead of you staying at home, come to work. Now, what the state did was to say, instead of the state to focus on those that have underlying health conditions and the elderly, and say to them, we are going to put these resources in terms of saving lives. I agree with the state in terms of saving lives.
Yes.
So let's save lives. If the state wanted to save lives, it would have had a clear focus based on the assessment report.
Mr. Motopeng, getting back to this application, so your argument is that the measures taken weren't rational and therefore they should be struck down and an appeal against that should not be allowed.
My Lord, you are saying,
Mr. Motapeng,
Yes.
in conclusion, just when you were allowed to join as an amicus and in the judgment as well, well, at that time and in the judgment, I raised the issue of multiplicity of actions. Just from the bench, seeing that you now have the floor, what happened to the HBR's application?
My Lord, for now, we felt that it is important to advance this course.
You're currently limited to being an amicus in this matter.
Well, no, my Lord, we want it to be an application, my Lord. In fact, we still want to be an application.
Yes.
Yes.
But that one hasn't been lodged again.
Well, you see, we are laymen, my Lord. Now, as laymen, we thought probably by being amicus, we are now somewhere, somehow, we might end up being applicants. And when you declare the...
Well, as an amicus, to assist the court, you have been heard. And I have your papers and I have your heads.
Thank you, Madam.
Thank you. Thank you, Mr. Motapeng. The Pringle?
May I say apropos comments made by all three parties. My learned friend suggested that the state is engaging in formalism. Mr. Lear spoke about technicality. The amicus speaks about the government callous to the plight of the poor. Those comments trivialize this debate. This is a very, very serious matter. Because what is common cause is that the government always acted in defense of the right to life. The right to life of every one of us, including the poor people for whom the amicus claims to speak. And what the state has had to do is to balance the demands of protection of the right to life with the demands for the protection of other material rights. And that debate is a serious debate, and it's a difficult debate. It's a worthy debate. The citizens are entitled, as these parties are, to come to court to challenge the government on the way in which they have struck their balance. But it is a serious debate. It's not a trivial debate. It's not technical. It's not formalistic. And it's not merely a callous government, callous to the plight of the poor. Government is acting in defense of the lives of the poor. Debate with them where that line must be drawn, but acknowledge that it's a serious debate. When we come to pleading, we have submitted with the greatest of respect that the way in which this case has been pleaded precluded an outcome of the kind that is called forward. Let me perhaps, if I may add one further reference to your Constitutional Court judgment, which is perhaps more apt to this particular case. It is a judgment in the case of Mazibuku v. Sisulu, 2013, volume 11, BCLR, page 1297, judgment of the Constitutional Court, paragraph 138. And let me immediately say this was a judgment for 4 judges, and they were not the majority in that case. But they firstly applied the test of shape, and secondly, insofar as we are concerned in this debate, merely on the conclusion to which another court might reasonably come, the application of the pleading principle by 4 judges of the Constitutional Court is a significant assistance. Now, in paragraph 138, judges said the following. There was also an attack on some regulations, some rules. This pleading does not identify the rules that are inconsistent with the Constitution, nor does it state which provision of the Constitution is breached by the identified rules, by the unidentified rules. The essential information does not appear anywhere in the affidavit deposed to by the applicant and filed in support of a direct access application. One remains in the dark as to which rules are inconsistent with the Constitution and against which provisions of the Constitution the impugned rules may be tested for constitutional invalidity. The task of the constitutional adjudication in these circumstances becomes difficult to carry out. But fortunately, the solution is a simple one. The defect in the applicant's papers is fatal to the claim, and therefore it fails at the starting line. As was observed in Sheikh, the Minister of Justice, to require accuracy in the identification of challenged provisions constitutes sound discipline in constitutional litigation. Now, I'm not going to belabor that issue. My learned friend says that his juniors tell him that the constitutional attack was pleaded. But with respect, my Lord, I actually read the affidavit, and it doesn't plead with that. I don't know whether your Lordship has the founding affidavit at hand,
Yes.
but it's on page 9 of the founding affidavit, which is in the case lines, volume 6, page 10.
I'm with you.
Your Lordship will see that there is a summary given of the attacks made. And I'm not going to take your Lordship through all of it, but what it does is to raise very specific targeted attacks from paragraph 3.1 through over a number of pages up to page 13. Very specific attacks on very specific provisions. None of those specific attacks are held. The only place where it then raises a general attack is in paragraph 311, when it says, in general, these regulations have violated almost all clauses in the Bill of Rights of most of our citizens. In that process, the Minister has especially humiliated and trampled upon the dignity of mostly the vulnerable, low to medium income earners of our country and our foreign guests. So that was the only general attack. And that general attack is then dealt with in particular
In paragraph 10.
in paragraph 10.
Yes.
And we submit with respect to the law, that is a deficient pleading of anything more than those specific attacks. And therefore, the court's order, which did not uphold the specific attacks, but went beyond it and upheld the general attack, was not rooted in a proper pleading. Lastly, my Lord, even if we are wrong on that score, the Lordship emphasized that there are two bases upon which leave to appeal might be granted. The first is that not that the appeal will be successful, but that the appeal will have a reasonable prospect of success, and address that issue. But the second is that there are, even if it does not have a reasonable prospect of success, that there are compelling reasons of public interest to allow leave to appeal. Now we submit with respect that it's hard to imagine a case with more compelling reason in the public interest to allow leave to appeal for the SCA to determine whether the judgment is correct, because if it is, it's of profound public importance, or that the judgment is incorrect, which if it is equally of profound public importance. And we submit with respect to the law that even regardless prospects of success, this is a case which not only needs to be determined by the SCA, but needs to be determined urgently. Your Lordship will have seen that we ask this court to grant urgently to appeal to the SCA. Of course, it's up to that court to determine when and how to hear us. But this court's acknowledgement that it is an urgent matter would be a valuable voice in that determination.
Yes, although I think if leave is granted, the Supreme Court of Appeal Registrar would be the one to be approached on urgency.
Well, whoever has to be decided, whoever has to take the decision on urgency would be aided by the view of the Court of First Instance on the urgency of the matter.
Yes.
Thank you.
Thank you, Mr. Chairman.
Might I just, a matter of correction, not to have the last right at the cherry, but just a correction. My submission to Lordship wasn't that my little junior informed me as to what the papers, I too read the papers, was to say that he was in court on that occasion, as was my attorney, and that Mr. De Beer was the originator of the papers, not any of the lawyers. As you wish.
Yes, well, that's the point to say, that's in underlying your point to say it was a lay person who drafted the papers, and it's a lay party who then drafted and proceeded with their argument.
That's right. That's, I don't want to overstep the mark. Thank you.
Thank you. Well, I thank the parties. The previous judgment was granted under extreme time pressures and in relative short term. I will, having regard to the nature of the application and the stressed importance of urgency, also adhere to similar time frames, but not bind myself to a specific date. It will be shortly. That judgment will be handed down. The parties will be informed electronically, and it will be uploaded in case lines. But until then, judgment is reserved. Court adjourned.
All right.